Swayam Prabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my 7th lecture on decree and order. You know this thing, in our definition clause we have this decree and order, section 2.2 of our CPC defines decree and section 2.14, clause 14 defines order. This word, because we have already discussed number of things in this lecture series like suit of civil nature, res judicata, place of suing, suit by indigent person, suit by minor, temporary injunctions. So, now I think this topic becomes relevant. So, that is the reason I have kept it on 7th number, this decree and order. Normally in our classes we teach first what is decree and what is order, but I think this is not right approach. Till now you have already known or you have already come to know about suits, I mean what is suit and what is civil nature and all those things, different res judicata, number of things, and number of times this question also came during our discussion, like court passes basically decree, court passes this order. For example, interlocutory orders. So, interlocutory order is also order. So, now temporary injunction is a temporary relief, permanent injunction is a permanent relief. So, this word, now I think if you understand this one and relate with all those substantive aspects what we have discussed earlier in this lecture series, then you can easily come to know the meaning of these words decree and order, how you get decree in civil matter, how you get order in civil cases. So, let us start with this introduction, like what is decree. So, basically section 2.2 of the Code of Civil Procedure defines this decree. First I will clear this, read the language of this word decree 2.2, because this language bare act language is very important. Without it, because you will get all points in the definition itself, and then will clear one by one what is formal expression, what is adjudication, what is suit, or what is conclusive nature, all those things we will discuss one by one. But I think first we start with this definition, what is decree. Decree means the formal expression. You can point out or you can mark these things, like because with this if you mark it, then you can easily relate it with the bare act also. Decree means the formal expression, first one is formal expression, although order is also formal expression, but here decrees, I will let you know what is the difference between this decree formal expression or order when we call this is also formal expression. Then second one is adjudication, this is the second feature. The first feature is formal expression. Decree always you get in the form of writing, or this is a formal expression. After deciding the case, court normally passes decrees in civil matters. Then adjudication. Adjudication word is again very important, like there must be a adjudication, judicial determination of your issues, judicial determination of your case, and adjudication or judicial determination basically comes in civil matters in your cases. Second one, and this is second feature. Third one, the court expressing it conclusively determines the right of the parties with regard to all or any of the matter in controversy in this. Conclusively determine. Decree again, apart from this formal expression, this feature adjudication, and third one conclusive determination. This is not a temporary injunction, because temporary injunction for the time, temporary relief you get for the time, order you get for the time being, that is mentioned in the order itself, in the court order sheet itself. Okay, this order is for this much time is effective, but decree is a conclusive determination of your all issues, whatever is being framed, whatever is being decided by the case, issues under order 14 of CPC. That is conclusive determination. I will let you know in further. And third one, with regard to all or any of the matter, because there can be number of matter in one civil suit. It is not a question of, suppose there can be 5 matters, there can be 5 issues or 10 issues, depending on the nature of the case, depending on the cause of action. And last one, in suit, this feature, suit is also, decree always comes in suit, civil suit. It means civil proceeding, what you have studied in section 9. What is civil proceeding, what is civil suit. So, this word is, I mean, specifically mentioning this word civil suit. Only when you file plaint, then you get this one, this decree. It may be either preliminary or final. In some cases you get sometime preliminary decree also, in some cases normally you get final decree, but there are a few examples, and with the help of those examples you can come to know, I mean, there can be preliminary decree also. Students normally get confused, ki sir, what is the difference between preliminary decree and final decree. So, I will let you know this one also. It shall be deemed to include the rejection of a plaint. Decree also include rejection of plaint, order 7 rule 11, rejection of plaint, order 7 rule 11. This is also decree. Normally we call it, this is deemed decree. Another one, determination of any question within section 44 of CPC, restitution. 44 talks about restitution. You should know the meaning, restitution. So, this is also decree, but what would not come in the definition of decree? Any adjudication from which an appeal lies as an appeal from an order. If you prefer appeal in your case, then that decree is not final and that would not come within the purview of decree. Decree means when after the expiry of the appeal time, what comes, or if you feel this is okay, now you are not approaching the appellate court, then that is decree. Otherwise, if you approach appellate court, then that is not one, that would not come within the definition of decree. Another one, any order of dismissal for default, if you are not appearing after filing your case, this kind of order is also not decree. And this one explanation also you can go through, because this language is important. Without reading or without understanding first, or without reading it properly, you cannot come to know further what are the meanings of feature, what kind of essential features are there of decree. So, that is the reason I am reading. A decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. It is final when such adjudication completely disposes of the suit. It may be partly preliminary and partly final. Now, see, these are the essential features. We will come to know one by one. Earlier we have studied this definition. So, now this one, essential features of decree. First one is adjudication. What is adjudication? Adjudication means judicial determination of your case. Adjudication, there must be judicial, you can come to know with this one, judicial determination of your case. Judicial determination. First, in order to come to know what is decree, you have to understand there must be an adjudication, adjudication in civil case, adjudication in civil matter, what you file through the presentation of plaint under order 7 of CPC, adjudication, and that must be judicial determination. If you get any order, if you get any adjudication from other, like for example, from in any administrative matter, administrative suit, or by the authority which is not a court, then that kind of order is not a decree. If you get any order or any decree, basically any adjudication only from the judicial authority which is amounted as court, then you can say this is decree. Adjudication, what you get from the judicial authority, what you get from the courts, what you get from the judges, that kind of adjudication must be there. There are number of things like to whom you can call, whether this is adjudication or this is not adjudication. I already told you, like administrative matters from executive authority, because executive authorities are not court, judicial courts. Apart from it, administrative matters, what you get from different administrative cases, that is not judicial decree, that is not adjudication. So, there must be a judicial determination of your issues, judicial determination of issues. This is also one another thing, issues. Issues basically we frame for this, for understanding this decree. I mean, apart from these features, what I will suggest you, first you have to keep in your mind the complete structure of your trial. Then I think you can easily come to know, you can easily relate these features. Like adjudication, it means there must be a civil suit. There must be a civil suit means the entire civil proceeding must be there. What comes on first date, it means from beginning to end, the trial procedure you have to understand from beginning to end what happens in civil cases. Then you can understand ki only in these kind of things, in these kind of cases we get adjudication, we get judicial determination of issues. Like for example, on the first date of hearing, basically you people file civil case through the presentation of plaint. This is the first stage of your civil matter. Civil matter through the presentation of plaint under order 7, what you draft as per order 7, plaint. Order 6 talks about pleading, order 7 talks about plaint, order 8 talk about written statement. So, pleading include both plaint and written statement. Plaint as per order 7 means what is filed by the plaintiff, who has a sort of, I mean, who feel ki the party is aggrieved one, who feels he is aggrieved one, that person is called plaintiff. This is also very minute understanding, because you people are new one in CPC. So, that is the reason I am telling you even these basic things also. Plaintiff means who is approaching the court, whose rights has been violated, who feels he is aggrieved one, and defendant means against whom we are filing our case, against whom or from whom we are claiming our relief, that is called defendant. So, on the first date of hearing, plaintiff prepare plaint as per order 7 of CPC. He mentions, okay, this is cause of action, this is the entire story. Order 7 rule 1 itself, if you go through those 10 or 11 points, you will come to know, yes, these are the particulars or these are the contents of plaint. Then through that you will file your case, and after this case, on the first date of hearing, court will examine you whether really you are genuine one or not. Then court will issue summon to the opposite party defendant. If there is a case is made out, prima facie case made out, then court will issue notice to the opposite party, it means to the defendant. Then defendant will come and file written statement as per order 8 of CPC. Written statement, you people can call it reply also. Written statement or reply by the defendant, because he has to defend his case, he has to know this thing, because with the summons he got even the copy of plaint also, and now he has already come to know, defendant opposite party, he has already come to know, okay, this is the case against me and this is my reply, whether specific denial or this kind of specific admission of your case, depends on you. You will mention, you will write in your written statement. Then after issuing or after going through plaint and written statement, court will frame issues. This is the third stage. You have to keep these stages in your mind. If you understand, you can draw even a diagram also and keep just always before you. If CPC is not coming in your mind, if you are not understanding CPC civil procedure code properly, because people normally, students ask this question, sir, CPC is difficult. But if you keep this kind of diagram before you, if you always I mean relate these provisions, this order, these rules with the diagram, okay, this is the first stage, on first stage we file plaint, then court will serve notice, summon to the opposite party as per order 5 of CPC, then opposite party will come with written statement under order 8 of CPC. After going through plaint and written statement, court will frame issues as per order 14 of CPC, very important order, because in criminal matters you heard about charges, court frame charges after getting police report. court frames charges, but in civil matter we frame or the court frames issues, issues of law, issues of fact. These issues basically mainly we have these two issues, issues of law and issues of fact. Order 14 rule 1 and 2 is very important. You should read order 14 for this one. What is issues of law, what is issue, there are few examples also. What is issues of law and what is issues of fact. In our res judicata discussion also I have told you matter in issue, matter can be of two kind, matter of law and matter of fact, directly and substantially in issue, collateral and incidental in issue. But again here I am telling you, I do not know whether you got it or not, but again I am telling you, in order 14 after reading plaint and written statement, court frame these issues, issues of fact and issues of law. On the basis out of the plaint and written statement, out of the pleading, court will frame issues and court will frame issues of law and issues of law. Okay. Issues of law means issues means what is the point of controversy between you, what is the point of determination. This is what I am telling you, this is judicial determination. I am relating these features of decree with these stages of civil trial. If you understand, then you can easily relate it. So try to understand judicial determination, this is judicial determination. Otherwise pleading is, plaint is drafted by plaintiff, written statement is by defendant. Then court after going through plaint and written statement and after hearing both the parties will frame few issues, and those issues for example, suppose there is a matter suit for recovery of possession of immovable property, suit for recovery of possession of immovable property. Suppose somebody has dispossessed you, then what kind of issues court will frame? Issue number 1, issue means question number 1, because court has to answer, court will invite evidence on those issues. Then you will come to know this meaning of adjudication, you will come to know the meaning of in this one conclusive determination of your right. Adjudication must determining the right of the parties. You will understand conclusive in nature, otherwise you will not understand if you do not understand this what I am telling you right now. After court will frame few issues, for example what I told you right now, if there is a suit for recovery of possession of immovable property, if somebody has dispossessed you illegally, then you will file suit either for under specific relief act or for recovery of this one, because that is also civil matter. So you have to understand this one also. Then first issue would be who is in possession right now. This is the first issue, what the concerned party has to answer. Who is in possession? You can write down these issues also. How court frames issues, how you people can argue on issues, how you people can justify this is relevant issue or not. If you feel this is not relevant issue, then you can point out the court, because court takes signature on charge sheet. You can point out the things to the court. No, your lordship, this issue is not a relevant one, or this is not the point of controversy, because sometimes there can be communication gap between advocate and court also. So who is in possession right now? Second issue would be since how long he is in possession, since how long he is in possession, because otherwise through adverse possession also the party can become the owner of the property. Since how long the party is in possession, if the court get answer of first issue, who is in possession. Second issue, since how long he is in possession. Third issue, whether possession is peaceful or not. This would be or can be third issue. So similarly, as per the matter, this is only one example I have just for your understanding, because I want to make you understand how the court frames issues. So just what I have told you in this particular case, how court framed issues. If you are satisfied with these issues, then you can sign, you can say okay, your lordship, we have no problem. If you are not satisfied, then you can say no, your lordship, this is not the right issue, this is the issue, this is the point of controversy. Point of controversy between plaintiff and defendant, court is concerned ultimately, because you write number of sometimes irrelevant thing also in plaint, and defendant also writes number of irrelevant things in written statement. Court is not concerned with all those irrelevant things. Court is concerned only with the point of controversy, and those point of controversy, that is the reason I am telling you ki these issues, court frames issues on the basis of your pleading, and these issues would be either of law or of fact. But if issues of law comes first, or if there is an issue of law, then court would decide first issues of law. Issues of law, example, jurisdiction related issues. This is issues of law. You have to find out the difference between issues of law and issues of fact. Jurisdiction related issues, whether court has jurisdiction or not. Court cannot proceed further without coming to know this thing, whether court has jurisdiction or not. Jurisdiction means authority to decide. Jurisdiction. If the court has no authority, because there are jurisdiction related, pecuniary jurisdiction, subject matter jurisdiction, territorial jurisdiction, appellate jurisdiction, original jurisdiction, all those jurisdictions are there. Authority to, because this provide basically authority to the court to decide the matter. So, these issues, if this kind of issues is there in your case, as per the cause of action, court will come to know this thing, whether court has jurisdiction or not. Then court will decide first this issue and then issues of fact, and this decree you will get, this decree is related, all these 5 points is related with the issues of fact, because there is a need of adjudication, a complete adjudication, final adjudication, and that must be through or in a civil case or civil proceeding. So, first issue, now you can relate these issues, how, what I told you right now, ki as per order 14 how court frames and court takes signature, then court will invite evidence. This would be the next stage. You people will submit list of witnesses, plaintiff will submit his own list of witnesses, defendant will submit his own list of witnesses. Then on the basis of one by one, chief examination will take place, cross examination will take place, and finally on the basis of the argument, court will conclude your case. These are these stages, minutely you have to understand these stages. This is, I have told you just only in brief, minutely you have to understand these different stages of civil matter, civil case. First, filing plaint, then serving notice or summon under order 5 of CPC, if the case is made out, because there sometimes there is no cause of action. On the first date of hearing, court decide there is no cause of action, then court will reject your plaint. Then written statement, then framing of issues, then some list of witnesses, then one by one chief examination, cross examination by the opposite party, then final argument and judgment, decree. This is the, in between also you can get different orders, interlocutory orders or orders, what you study basic normally in section 2 clause 14 of CPC. Lastly, after concluding the case, court can give judgment, then after judgment the final thing is decree, final order or final decision is called, or final adjudication is called decree. This is the difference. Judgment always comes before decree. Decree is the minute detail, complete, final decision. If you are satisfied, then it is okay. If you do, you can go in execution. If you are satisfied, if you are not satisfied, then you can go in appeal. So, this or in between, what I have already told you. In between also, if you feel no, this instant relief also you need. Instant reliefs are called order. Just for your understanding, I am telling you, although this is based on your application, whether court accept it or not. Like status quo, this is order, return of plaint, if court do not find anything or court do not find jurisdiction over the matter, then court can return your plaint also under order 7 rule 10 of CPC. Amendment of pleading, order 6 rule 17, if you feel no, you need sort of amendment in your case, then also court can say no, whether court can accept it or if court reject it, then also that would be counted as order. So, different relief what you claim as per the rules of different order, as per the rules of different order. misjoinder and non-joinder, substitution of parties, return of plaint. These different, there can be number of orders, because you have number of rules, number of orders, number of rules further you have. So, accordingly court can pass those orders also. So, what I am telling you now with this structure, or I have given you a structure of civil case, structure of civil matter. So, first there must be an adjudication, because we are here understanding what is decree. Decree is a formal expression, decree is an adjudication, decree is a conclusive determination of your case. So, decree means first there must be an adjudication, and that must be done in a suit. Suit means civil suit or civil proceeding, civil suit or civil proceeding, and civil suit always filed as per order, as per order 7 of CPC. Adjudication must be done in a suit, civil suit, and civil suit always filed. This is not decree, you do not get on the basis of the application or by presenting an application. You get decree by presentation of a plaint. So, this is also the first condition, the prerequisite one, precondition of this decree. If you file civil suit as per order 7, if you file plaint, then you can say, and civil proceeding or civil suit, for that, for civil suit you have to follow the civil proceeding. Civil proceeding, civil proceeding includes all those stages what I told you right now. Civil proceeding, number of times we call civil suit means civil proceeding. Civil proceeding means what is happening or what is taking place from beginning to end. You have to understand these words carefully, what I am telling you. Although already I told you, you have to make a diagram, draw a diagram of this all stages of civil suit, then fit your all orders and rules and sections accordingly as per the need of your stages of your civil case. So, civil proceeding means what is taking place from beginning to end of or during trial, I will say during trial of your case, that is called civil proceeding, that is called civil suit. So, decree always you get in a civil suit. And why we are calling ki there must be an adjudication? We are calling because this is a judicial determination of your case, judicial determination of your issues, what is framed by the court, and that decides your right of the parties, right of the party, because it conclusively determines the right of the party with regard to all or any of the matter in controversy. If you study this definition properly, if you read this definition, ki conclusively determines the right of the party with regard to all or any of the matter in controversy in the suit, conclusively determines. If there is a temporary relief, then that is not decree. What is conclusive determination? And that conclusive determination can be of your all or any of the matter in controversy. I have already given example of this case, like suit for recovery of or for getting possession of immovable property. There can be number of issues, there can be number of matter in one civil suit, there can be number of matters, keep this thing in mind. There can be number of matters, 5 matters, 10 matters, you can call it issues also, no problem. There can be number of issues in your civil case, depending on the cause of action, depending on the case, what you are claiming or what you are filing before the court. Court cannot go beyond your plaint, court cannot go beyond the written statement, court has to first read the plaint or the entire pleading, plaint and written statement, then court frames issues or court frames matters, matters of controversy, matter of dispute between plaintiff and defendant. We call it ki this is judicial determination, we call it this is point of determination, what the court has to determine, what the court has to decide. Court decides. So, that is the reason I am telling you again, conclusive determination, the right of the party. Right means substantive rights, not procedural rights, like whether the suit is maintainable. Substantive right, you understand the difference between substantive law and procedural law. CPC is a procedural law, CRPC is a procedural law, Evidence Act is also a mixture of both procedural and substantive, Limitation Act again is a procedural law, but your constitution of law is a substantive law. Law of contract is a substantive law, where you come to know the basic rights, about basic rights, where you get knowledge, that is called substantive law. IPC, Indian Penal Code, your all other legislations, when they are talking, because they are talking about your civil, your substantive rights. This is the difference between substantive rights. So, conclusive determination, the right of the party, that is the reason I am telling you why they have written here right of the parties. Right of the parties means because you are concerned only with the issues of fact. Issues of fact means what is the plaint, what is the cause of action, issues of fact, these all are fact. Your entire plaint is a fact, and out of those fact, court will frame few fact or issues, court will frame or court will catch few issues, or court will frame few points of controversy and will frame issues accordingly. Fact and fact in issue, what you have studied in Indian Evidence Act, fact and fact in issues. Out of your fact, that is called plaint, and out of that plaint and written statement, court will catch few fact in issues. What is in issue, what is in dispute, what is in controversy, what is the problem of the concerned parties. That is the reason I am telling you right of the parties, only substantive right, not procedural, whether suit is maintainable one, how court would decide whether suit is maintainable one, and how this is related with the substantive right of your case, substantive rights of the parties. Maintainability is directly related with the cause of action, whether there is a genuine cause of action, whether there is a complete cause of action, whether the cause of action is legally enforceable or not. There are a number of things related with this one, cause of action. Otherwise, court will reject. Order 7, Rule 11, court will reject your plaint if there is no cause of action, if the cause of action is not legally enforceable. So, normally I suggest even to tell to my students, beginners, like they before filing your suit, you must understand this one, whether this is legally enforceable or not, or what is the difference between moral and social rights and legal rights. Sometimes we get confused, are social rights or also legal right. They are not legally enforceable, like helping someone on street. This is not legally enforceable. You can help if you have good sanskar, you will help him out. If you do not help him out, then it is okay, it is your choice. So, you can relate it. In law of torts, you study basically this thing also. Here we are talking about right of the parties, substantive right, conclusive determination. Conclusive determination take place finally on the merit of the case. You cannot say in beginning, or you cannot get, you cannot say just by getting one order under section 2 rule 14, this is conclusive determination. May or may not, we use normally this language for orders, may or may not decide your, because this order is a instant relief, this is for the time being, this is in interlocutory orders also I told you. So, conclusive determination, conclusively determining the right of the party with regard to all or any of the matter in controversy, all. Court is nowhere in this picture, because the moment court demand or court ask for the submission of list of witnesses, then both the advocates through examination, cross examination, or list of witnesses, production of witnesses, or through primary document, primary evidence, they prove their case. So, if they prove, if they bring all evidences related to all issues, what is there, what is framed by the court, then court will give judgment on all issues. If you do not bring evidence, plaintiff and defendant both do not bring evidence, or they do not prove through chief examination and cross examination, they do not produce any witness, neither they produce any witness nor they bring any sort of evidence, primary evidence, then court cannot on and on decide, or court will not on and on decide your all issues. Whatever the evidence you are giving, court will decide on the basis of your evidence. If you give, if you prove all issues, all, this is the meaning of all and any of the matter in controversy. If there are 5 issues, if you give evidence and prove all 5 issues, then it is okay, court will give judgment on all 5 issues. If you do not prove any issues, or suppose out of 5 you prove suppose 3 issues, then court will give judgment on 3 issues and you will get decree accordingly. This is your case, the case of plaintiff and defendant, the case of concerned parties. So, in advance they must be vigilant, they must be aware about this one, how to prove their case. Filing case and proving case both are two different things. Filing is not mean ki automatically court will justify the case or court will accept your case. So, decree basically I am telling you ki how this is formal expression, how this is called adjudication and conclusively determines the right of the parties. That is substantive right, not procedural right, already told you, like example I have already given, maintainability of suit, conclusive determination with regard to all or any of the matter in controversy in the suit. It may be either preliminary or final. This decree can be preliminary or final also. In some examples I have given. So, this can be final and this includes rejection of plaint and determination of any question within section 144. I let you know this one how this can be, I mean rejection of plaint also comes within this. So, I hope you understood all these 5 essentials of decree. Now, I am coming on directly on this one deemed decree, because order 7 rule 11 is also deemed decree. You must know what is rejection of plaint, you must know what is restitution. So, this is also again cannot be termed as decree, you can read this one and I will let you know directly what is rejection of plaint. Order 7 rule 11, normally I say this one decree would decree include even rejection of plaint also. Rejection of plaint means rejection and return, both these are two different things, where it does not disclose a cause of action. Although I have told you, but just for the sake of your convenience, I am telling you this is also decree and this order is also decree. This order 7 rule 11 application, if you get any relief, this is also decree. 144 order, if you get any order on section 144 restitution, that is also decree, and these two reliefs are called deemed decree. Deemed decree, likely to be a decree. And what is rejection of plaint? When your plaint does not disclose a cause of action, although already we have discussed, depending on what relief, what fact you are bringing before the court, putting before the court, that is called whether your plaint discloses a cause of action or not. On the first date of hearing, court examine the plaintiff, court examine the concerned party, what is your name, what is your cause of action, why you have filed this case, what you are claiming, just to ensure this one, just to ensure whether really you are genuine one or not, whether really case is made out or not. Sometimes facts and vexatious kind of claims are also there, fake cases, fake claims are also there, just to discourage all those kind of things. Second one, where the relief claimed is undervalued and the plaintiff on being required by the court to correct the valuation within a time to be fixed by the court fails to do so. Undervalued, you have studied already Consumer Protection Act. As per the value, like there is a pecuniary jurisdiction, up to 10 lakh district firm will decide, up to from 10 to 1 crore state commission will decide, and more than this crore national commission will decide. So, valuation, you value the property and accordingly you file the court fees, you purchase the stamp paper, you purchase the stamp duty. So, valuation must be there, because this money will go in the treasure of the government, state government. So, if you do not value, like normally I give examples, if you purchase a plot of land, then you pay registration charges 3%, 5% or 7%, urban areas and rural areas as per. In urban areas we pay 7%, in rural areas I think we pay 3%. For male and female also this difference is there, 3 and 5 and 7%. In urban areas for male this is 7% and for female this is 5%. So, valuation must be there, you purchase stamp duty, you purchase stamp paper as per the valuation. So, similarly in civil matter also you have to value the suit, value the property, whether you are claiming 10 lakh rupees or 20 exactly, and pay stamp duty accordingly. Otherwise, this will be a loss, because this is paid service. So, where the relief claimed is undervalued, suppose you value it just to save your money, just to not to purchase your stamp duty or stamp paper. If you undervalue your property, then court, if comes to know, then court will reject your application. Where the relief claimed is properly valued, but the plaint is returned upon paper insufficiently stamped. Sometime you properly value the property, but insufficient paper you attach. you purchase insufficient paper, then also this can be a ground of rejection of plaint. Third one, where the suit appears from the statement in the plaint to be barred by any law, if your matter otherwise by limitation act or on account of any other bar, if there is any other bar, then also court will reject, court will not entertain your plaint under order 7 of CPC. Third one, next one, where it is not filed in duplicate, where the plaintiff fails to comply with the provision of rule 9, rule 9 of this one, order 7 itself, or rule 9, order 7, you can go through, because the number as per the number of defendant, you have to submit the copy. If there are 5 defendants, then 5 copies, then accordingly you will pay the postal charges also. 5 defendant, it means whatever is ordered by the court, 100 rupees per defendant, then it means 100 into 5, 500 you have to deposit in advance, then court will serve the summons to the opposite party through postal services. So, otherwise court will reject. This is your rejection of plaint. Next, restitution. Restitution, if see this one, where and insofar as a decree or an order is varied, reversed in an appeal, if you approach the appellate court and your decree or order, whatever is passed by the, or whatever has been passed by the lower court, that is varied, that is reversed in any appeal. Appellate court has very much ample power, they can reverse your entire judgment. Today you are decree holder, tomorrow you will be judgment debtor. Power of appellate court. Court can exercise power judicially, appellate court can exercise. So, if your decision is reversed or varied, there can be changes also, what is suggested by the appellate court as per the suggestion. If there is a reversal, if there is a variation in your judgment decree or order, alteration in decree or order, earlier the relief was something else, now earlier the rate of interest was 9%, which was awarded by the lower court, now the appellate court reduces it from 9 to 7%. So, this kind of variation can be there. So, other proceeding or set aside or modified, see this one, read, you have to read it very carefully. Setting aside, modification in any suit instituted for the purpose, the court which passed the decree or order shall, on the application of any party entitled to any benefit by way of restitution or otherwise, cause such restitution to be made as will, so far as may be, place the party in the position which they would have occupied, but for such decree or order has been varied or verified, the court may make any orders, including order for the refund of cost, for the payment of interest, this relief you can get, damages you can get back, compensation you can get, mean profit you can get, if there is a variation, if there is a alteration, if there is a reversal, setting aside or modification of your decree, then this kind of things you can get back, although you are decree holder already enjoyed it. But if you are in appeal, sometime this can happen, I mean this is unforeseen thing, but this can also happen. If you are decree holder always wait for the time of appeal. Sometimes you do all these things in haste, being a decree holder you feel no, lower court has got this decision in my favor, let me do, I mean as per the decision whatever I have right now I can use it now. If you do it, then if appellate court changes the decision, then you have to suffer this one consequences, keep all these points in your mind. This can be the consequence, payment of interest, refund of cost, damages, compensation, mean profit, or apart from it other things what is ordered by. This is also a deemed decree, restitution, this is called restitution and this is deemed decree. So, apart from this I will tell you how decree can be preliminary one, because this is the classification of decree, preliminary decree, final decree, partly preliminary and partly final, deemed decree. Deemed decree I have already discussed, because this was directly coming in section 2. So, that is the reason I have taken it first. Rejection of plaint and restitution is called deemed decree. Rejection of plaint under order 7 rule 11 is decree, deemed decree, and restitution under section 144 is deemed decree. You can write it in bracket also, order 7 rule 11 rejection of plaint and section 144. These are the examples of this deemed decree. With these examples you can come to know, otherwise sometimes on the spot if somebody asks what is deemed decree, you get confused also. If you give these examples, then I mean remember these examples, you can also keep in your mind. Okay, order 7 rule 11 is the example of deemed decree, and section 144 is also the example of deemed decree. Now, what is preliminary decree? See this one. Preliminary decree may be a decree where the court decides the right of the parties concerning all or any of the matter in conflict, but does not determine the finally. Does not determine the finally, and these are the examples. These are the examples. This list is not exhaustive one. There are a number of examples. Preliminary decree basically not deciding your case permanently. Normally you get final decree, but there are number of examples like suit for possession and mean profit, both are two different things. Suit for recovery of immovable property and mean profit is related with the possession of immovable property. What you get if you get possession, illegally possession of some other property, and out of that property if you get short of interest, rent, suppose you dispossessed from my immovable property and you get rent out of that property, immovable property, then that rent, if there is an improvement, then that would not be taken back. But if you have recovered something illegally, although because you are not entitled for this rent, I am entitled because I am the real owner of this property. But if you are dispossessing me and you are getting the rent of this property, or otherwise ordinary man what he could have got or what he would have got, I will say instead of this one, then he will be entitled to get, I will be entitled to get mean profit, because you wrongly dispossessed me, you wrongly dispossessed me. So, mean profit are different thing and possession of property is different thing. If this and this is related, this will coexist. If there is a dispossession of from immovable property, then definitely the party will claim or file application for this mean profit also. This is also mean profit is also there in order to rule 12, I think. Mean profit definition is there, and in order 20 rule 12, order 20 you can go through, and rule 12 how this preliminary decree can be passed. Order 20 is specifically rule 12 is talking about this, in this kind of cases there can be preliminary decree. Next one, administrative matter. Administrative matters are also confusing one. There are a number of things what you claim, small relief you claim, the complicated matter, the minute matter, administrative matter. Administration, like imagine executive positions, how they take decisions, how the matters are completed from one table to another table, from another table to another table. Due to red tapeism, there are a number of things. So, administrative suits also there can be, if you get today one relief, you will get order, but that is preliminary decree, that is not final one. Partnership matter, dissolution of partnership in Partnership Act 1932, and this order rule 20, rule 15, dissolution of partnership I am talking. Dissolution of partner includes number of activities, number of things. Dissolution, you are coming to an end, now you are shutting down the partnership firms. Dissolution, how many partners are there, how many accounts are there, from how many banks the partnership firm has taken loan. There are number of issues, there can be number of issues relating to dissolution of partnership. So, in these cases also you can get preliminary decree, otherwise you get final decree. But if the matter is complicated one, if the matter includes or contains number of small things, small decisions, number of small applications, then you always get preliminary decree. These are the examples just for your understanding. This list is not exhaustive one, student confused, they ask this question number of times in class, what is preliminary decree sir, what is deemed decree, what is final decree. Always I say that the decree is always final, but there are few examples, with the help of those examples we try to make them understand, okay, in these cases also you can get preliminary decree. And you should imagine this one, partnership, dissolution of partnership one, administrative suit, suit for possession and mean profit, and this one preemption suits. So, these are the few examples of preliminary decree, because they are not determining the rights and they cannot decide, because number of things are involved in the case, number of decisions involved in the case. How court can decide just by giving one decision? That is the reason we are calling it this is preliminary decree on the basis of some preliminary issues. Sometimes preliminary issues also comes. So, that is the reason, because this issues final decision will be you get with the help of final decree, but this is preliminary decree on preliminary issues on some small matters. Preliminary issues means number of issues what I am telling you. Suits associated with the accounts between principal and agent. Imagine just this situation, separate possession, partition, imagine this position. In these cases you get sometimes preliminary decree. This is final one, already told you, decides all the matter in controversy and eventually disposes of the suit, it is called the final decree. This what we have understood already with the help of what are the essentials of final decree. Section 2.2, formal expression, conclusive determination of your case with conclusive determination of your right with regard to all or any of the matter in controversy. Adjudication must be given in a suit and it includes the rejection as well as restitution. This is final decree. Partly preliminary and partly final decree. Partly preliminary and partly final decree are those where a final judgment has been passed in respect of part of the suit and other part is left for future adjudication. For instance, during a suit for possession of immovable property with mean profit, the decree of the court regarding the possession may be final decree, whereas the decree about mean profit is preliminary in nature. You can understand with this help also, with the help of this example also, mean profit, because mean profit can fluctuate, that depends on the market rate, that depends upon the, because this is a question of calculation actually. This is a question of calculation. Court has to calculate what, for how much profit you are entitled. You have been legally dispossessed by someone, for how much profit you are entitled. So, that is the reason I am telling you mean profit is a preliminary in nature, this is not final one. If sort of different calculation comes, then court can similarly like maintenance, this increases and decreases as per the earning. Consent decree and ex parte decree. During consent decree and ex parte decree, consent decree what is passed with the mutual consent of the parties, although there is no appeal against it, mutual consent, and you get it recorded if you get decree, because decree is there. So, you will understand this one, consent decree, it means by the court, but that based on your mutual understanding of plaintiff and defendant, we are calling it consent decree. Ex parte decree, one sided order 9, rule 6, one sided decree, ex parte decree. In rule 13 you have different relief also for this one, appeal, provision, review, setting aside. So, ex parte decree means one sided decree. If your defendant is not coming, opposite party is not coming, then after serving summons, after waiting for some time, court can pass ex parte decree also. So, this is the difference, just for your understanding what is the ex parte decree and what is consent decree. What is not a decree? If there is an appeal against the decree, you have not waited for the expiration of the appeal time, then that decree is that would not be a decree. If you approach the appellate court, first appeal or second appeal, whatever, any order of dismissal for default, if you are not appearing even after serving notice, then also that is called, that is not a decree. Order now, order 2, section 2, rule 14 means the formal, this is also formal expression of any decision of a civil court which is not a decree, will not call it decree, because this is now with the help of this difference you will understand more about it. The legal announcement of the judgment taken by the court defining the relationship of the party in the proceeding is called an order. On the contrary, an order is given in a suit initiated by the presentation of a plaint application. Decree is always by the presentation of a plaint, but order you can get even on the basis of the application, presentation of the application. This is finally deciding, decree is finally deciding, this is decree, this is decree, this is finally deciding your case, and this is order point. Decree is finally deciding your case and this proceeding is initiated by the presentation of the plaint, but order, because in the civil same suit you file different applications. There are a number of examples of order, res sub judice application under section 10, or apart from it number of different other orders, interlocutory orders, amendment of pleading order, order 6 rules, rule 17. So, this is basically you will file application as per order 6 rule 17, amendment application. We call it amendment application, we do not call it amendment suit, amendment application. So, in the same suit you will get different orders, you can get different orders as per the need, as per the demand of the concerned parties, and this is basically substantively deciding the parties, and this is also different other procedural rights. So, these points are there. There can be many orders in one suit, but decree is always one, that is either final or sometimes preliminary also, but there can be number of orders in one suit, civil suit, there can be number of orders, because this is based on your application, this is based on your instant relief, instant need of your case. Decree can be preliminary, order is always final, because so far as application is concerned, if you get, suppose take example another one, condonation of delay, section 5 of your limitation act. So, that is final if court condones your delay, no further relief you need for this one, you will proceed with your case. Orders, there are some orders which are decrees are always applicable, section 96 discuss first appeal, section 100 discuss second appeal, and further 109 discuss third appeal to Supreme Court. Supreme Court, these are different provisions of appeal. Decree is always applicable, but there is orders are applicable as well as non applicable also. Order 43, there are list of few orders which are applicable, otherwise rest of the orders are not applicable. For this one, which orders are applicable, you should go through order 43 of Civil Procedure Code. So, this is all about decree and order. If you take it, if you hear or attend this session sincerely, then definitely I will hope you will get benefit out of this session, and you will come to know the difference between decree and order. Thank you.